Lawmakers in Washington, D.C. have stripped an amendment of next year's National Defense Authorization Act that could have kept the government from indefinitely detaining U.S. citizens without charge or trial. A grassroots movement and their supporters recently called upon the public to pack the courtroom on February 6 to show support for challenging the indefinite detention provisions of the NDAA. The lawsuit is against the Obama administration and members of the U.S. Congress by a group including former New York Times reporter and current Truthdig columnist Christopher Hedges, challenging the NDAA on allowing the U.S. government to indefinitely detain people who are part of or substantially support al-Qaeda, the Taliban, or associated forces engaged in hostilities against the United States. Many investigative journalists, like Hedges himself, strongly believe for their own protection the law needs to clarify the difference between indirect and direct support and the exact meaning of associated forces. On this edition of Inside Out, we'll take a look at the National Defense Authorization Act, known as the NDAA, and what it means for journalists and citizens alike. Do join us. Shortly after the September 11, 2001 terror attacks, President George W. Bush announced the need to detain terror suspects indefinitely as an emergency measure. 11 years later, the United States not only continues to allow indefinite military detention, but every year Congress threatens to make it worse. Last year, Congress, through the National Defense Authorization Act that authorizes funding for the military, expanded the category of terror suspects that could be held indefinitely by the military without charge or trial. Senator Lindsey Graham, a Republican from South Carolina, and others who supported the provision argued America's now the battlefield, so suspects picked up here should also be imprisoned indefinitely. This year, Senator James Inhofe, a Republican from Oklahoma, wants to require Guantanamo custody for all terror suspects. Senator Kelly Ayotte, a Republican from New Hampshire, would force the Pentagon to plan yet another offshore prison facility for them. In December 2011, President Obama signed the 2012 NDAA, National Defense Authorization Act, codifying indefinite military detention without charge or trial into law for the first time in American history. The NDAA's dangerous detention provisions would authorize the president and all future presidents to order the military to pick up and indefinitely imprison people captured anywhere in the world, far from any battlefield.
Under the Bush administration, similar claims of worldwide detention authority were used to hold U.S. citizens detained on U.S. soil in military custody. And a lot of people in Congress are now asserting that the NDAA should be used in the exact same way again. So now, under the National Defense Authorization Act for the fiscal year of 2012, U.S. citizens can be detained indefinitely without trial, while they can't contest the allegations against them because they have no right to be notified of the specific charges against them. And according to the actual text of the NDAA, the U.S. President can authorize the armed forces to indefinitely detain the following types of people.
The controversy lies around the legal meaning of what person is covered.
So it can be a person who was a part of or substantially supported al-Qaeda, Taliban, or any sort of associated force that were engaged in hostilities against the United States or its coalition partners, including anyone who has committed any sort of belligerent act or has directly supported such hostilities in aid of any of the enemy forces. To me, there seems to be a lot of potential implications for the abuse of the president's authority. And even though the White House and the Senate sponsors keep saying that the authorization for the use of military force, AUMF, already grants presidential authority for indefinite detention, this act states that Congress affirms authority and makes specific provisions as to the exercise of that authority. And the detention provisions of the act have received critical attention from a lot of different organizations and a lot of groups, including the American Civil Liberties Union, ACLU, the Bill of Rights Defense Committee, and then a few other media sources which are concerned about the scope of the president's authority, including contentions that those whom they claim may be held indefinitely, that could include U.S. citizens arrested on our soil. And these are arrests by members of the armed forces.
On January 13, 2012, a group of individuals from a wide range of backgrounds filed suit against President Obama, Panetta, and 6 members of Congress. The plaintiffs include activists, whistleblowers, authors, and professors, among them Chris Hedges, Daniel Ellsberg, and Jennifer Bolin, who is the founder of Revolution Truth, an organization dedicated to restoring legitimate democracies, in part through increasing access to accurate information. The campaign is called Stop NDAA. They believe their First Amendment rights have been violated and feel imminent danger due to the President's recent National Defense Authorization Act, specifically Section 1021 of the bill, that provides sweeping powers of detention through vague and undefined terms. They say it grants the government to arrest any American citizen or anyone anywhere without warrant and to indefinitely detain them without any charge. On February 6, hundreds packed a Manhattan courtroom to show support for the plaintiffs at the Second Circuit Court of Appeals.
The reason I'm here is, one, to make it very clear that we have to stand together to oppose the National Defense Authorization Act. This law is a very dangerous and draconian law that gives the government expanded authority, unprecedented authority, in this case, to arbitrarily detain indefinitely without charge or trial, people, under a broad and vague definition in which these people are said to have some vague association with terrorism or associated terrorist groups. And this law, the NDAA, would make indefinite military detention and military trials a permanent part of American law. It must be opposed.
I'm here today as a concerned citizen and a parent to ask for the repeal of the NDAA. It allows for the indefinite detention of citizens for allegedly consorting with terrorist organizations that are defined solely by the government.
On September 12, 2012, the suit had one of its biggest victories. Federal Judge Catherine Forrest granted a permanent injunction against Section 1021, but the government promptly filed an appeal and requested a stay of execution on the injunction from Judge Forrest. It did not, however, provide evidence and failed to answer all of her questions and concerns. Less than a month later, a stay against the permanent injunction was granted by a 3-judge motions panel of the 2nd District U.S. Court of Appeals, pending appeal on the merits, which resulted in this latest hearing.
Argued today the case challenging the NDAA in the Court of Appeals. This is one of the elite courts in the United States, and the judges, I think, were really up to the court's reputation. They were very sharp in their questions on both sides. They really challenged the government to prove that this is, in fact, not a new law, but an old law that merely has been recodified. The government's position is that the NDAA is merely an old 10-year-old copy of the old AUMF, which is the authority Congress gave the government to go to war in Afghanistan. We've dissected this in our briefs, and Judge Forrest in the trial court clearly agreed that this law broadens any pre-existing power of the military to detain people in this country. In fact, since the 1860s, the Supreme Court has held that no American may be detained in the United States by the military. There is a constitutional barrier between the military and the civilian, whether they are a citizen or not. The NDAA breaches that barrier. It allows, for the first time by law, the military to incarcerate citizens in this country.
Afron, who was speaking after the court hearing, continued that if this power is upheld, American citizens can be subject to military imprisonment.
We've seen professors incarcerated in this country because of such actions. We've seen at least one journalist taken by the U.S. in Yemen, Mr. Al-Hajj, who was later released after a long period of detention on this theory. Our client Chris Hedges was detained by the U.S. military long before this law was ever passed because he left a press pool. Surely if this law now exists, such endangerment is going to be more common. The government says that independent journalism is not subject to this law. Well, we don't know what that means. It's not in the law, that exception. And administrations change their view. In fact, Judge Kaplan bluntly said to the government, don't administrations frequently change their policies?
The U.S. government argues that the journalists and activists who sued the U.S. government to stop the indefinite military detention of terrorism suspect lack standing because they've never been detained or face no threat of detention. The government states that the term associated forces has been misunderstood. A brief explains that the term is well understood to cover co-belligerent groups that fight together with Al-Qaeda or Taliban forces in the armed conflict against the United States, and it is not and cannot be read to cover the types of unarmed advocacy organizations involved in this suit. They also note that none of the plaintiffs alleged having a fear of detention, nor have they offered any evidence of the U.S. military detaining journalists or advocates. Quote, there is no actual or imminent injury to be readdressed, the brief said. Additionally, there is no precedent for hearing a lawsuit to block the president in advance from conducting an armed conflict using congressionally confirmed authority. This is according to the defendants. However, in court, Chris Hedges said he was told when reporting in Saudi Arabia that he was on a watch list by a government official. He also knew that his phones were being tapped. And so in the hearing, on March 29, 2012, Judge Forrest asked Obama's lawyer if he could tell us the boundary of the NDAA law. The lawyer could not give specifics, stating it would take a case of someone being detained under the NDAA to find the parameters of the law.
This case is about keeping that barrier absolutely clear between the military and the civilian jurisdiction. The framers of the Constitution were very clear to make certain of two things. One, that the military is always commanded by civilians. And two, that the military will never have authority over civilians. This law changes that long-standing rule. And it is a threat to the basic liberty of people in this country. Do we think that concentration camps will arise from this? Of course not. But this is an erosion of basic principles of law. And it's our job as lawyers to stop that erosion before it grows further.
Carl Meyer, another lawyer for the plaintiffs, said they plan to take the case all the way up to the Supreme Court if needed.
The only hang-up that the judges seemed to have was they thought that the statute already exempted citizens and residents from detention within the United States. If we do nothing else but make it clear that that is the case, we will have won. Although we will, regardless of the opinion, if we do not prevail on everything, take it all the way up to the Supreme Court until we do prevail or have exhausted all of our remedies.
The Hedges complaint claimed that his extensive work overseas, particularly in the Middle East, covering terrorist or suspected terrorist organizations, could cause him to be categorized as a covered person, who by way of such writings, interviews, and or communications, quote, substantially supported or, quote, directly supported Al-Qaeda, the Taliban, or associated forces that are engaged in hostilities against the United States or its coalition partners under Section 1031 and the AUMF Authorization for Use of Military Force. Specifically, Hedges alleged in his complaint that it is precisely the existence of these terms that could allow him or someone in a substantially similar situation to be classified as an enemy combatant and sent away indefinitely to a military detainment center without access to an attorney or habeas corpus relief.
And what's happening in this court now is the last thin line of defense between protecting what is left of our anemic democracy and the imposition of a military state. The deterioration of civil liberties under the Obama administration has complete continuity with the attack on civil liberties under the Bush administration. In fact, under the Obama administration, it has been worse. And now, the National Defense Authorization Act, Section 1021, overturning 200 years of domestic law to allow the military onto our streets to seize American citizens, strip them of due process, put them in military facilities, including our offshore penal colonies, and hold them indefinitely. The corporate state knows what it's doing, if the Congress had put in one small sentence saying that U.S. citizens were exempt from this legislation, we would all pack up and go home, but they will not. Because as Senator Graham pointed out, it is designed to detain U.S. citizens. And the bottom line is, as this unrest continues, the corporate state does not trust the police to protect them. It wants the ability to call in the military. This case is one of the most important cases in decades in the protection of our most basic and important constitutional rights. And the heroes of this case are standing next to me.
Alexa O'Brien has designed digital content strategy solutions for international governmental organizations and Fortune 500 companies. She has covered WikiLeaks releases and revolutions across Egypt, Bahrain, and Yemen, as well as the case of Bradley Manning. Department of Homeland Security memos sent to law enforcement across the United States and different organizations said that her organization was likely to have high-level contact with cyber terrorists. The media followed suit, publishing those allegations and others, including her group's alleged association with al-Qaeda, jeopardizing Mrs. O'Brien's career and her standing in her community.
I've covered the WikiLeaks release of JTF memoranda known as the Guantanamo Files and revolutions across the Middle East and North Africa. I've conducted hours of interviews with former Gitmo prison guards, detainees, defense lawyers, and human rights activists. For the last year, I've covered the U.S. investigation of WikiLeaks, and to date, I've published the only publicly available transcripts for the secret prosecution of Bradley Manning taking place at Fort Meade. Because of my work as a journalist, government contractors attempted to falsely link a group which I helped found, whose only purpose is to support campaign finance reform in the United States, to al-Qaeda. They even published articles of their own, showcasing their ability to make Americans pay 100 times more for the insecurity we could have had for free, stating the group that I helped found was infiltrated with al-Qaeda and so-called cyber terrorists. Emails published by WikiLeaks indicated that other security contractors with ties to the U.S. government were specifically asked to connect this group to any Saudi or other fundamentalist Islamic organization. Section 1021 violates the First and Fifth Amendments of the U.S. Constitution, our greatest protection against threats to our liberty and national security. This legislative spawn of our national ideology, the war on terror, also preys on the spirits of people because it offers us the illusion of an identity, of dignity, of morality, making it easier for this nation and our people to part with them all.
O'Brien continued by calling the law arbitrary and deceptive and reiterated that the principal allegation made by the plaintiffs against the NDAA was that the vagueness of critical terms in the NDAA could be interpreted by the federal government in a way that authorizes them to label journalists and political activists who interview or support outspoken critics of the Obama administration's policies as covered persons, meaning they have given substantial support to terrorists or other associated groups, as Chris Hedges noted earlier.
Section 1021B2 was passed with bipartisan support, bought and paid for by lobbyists in one of this nation's most mistrusted congresses, and signed into law by Ad Age Marketer of the Year with a signing statement as arbitrary and deceptive as the Justice Department's about-face appeal and arguments in this very case. Let's dispense with the myth that the ubiquitous application of extrajudicial power is the exception to an unchecked executive. And let's dispense with the myth that Congress has the constitutional power to legislate the military detention of civilians. Let's also dispense with the myth that the U.S. government hasn't already detained journalists under the AUMF seeking to gain intelligence on media organizations.
Jessalyn Raddick is a former ethics advisor to the United States Department of Justice who came to prominence as a whistleblower after she disclosed that the Federal Bureau of Investigation, the FBI, committed an ethics violation in their interrogation of John Walker Lind. Lind came to be known as the American Taliban captured during the 2001 invasion of Afghanistan without an attorney present, and the Department of Justice attempted to suppress the information. The Lind case was the first major terrorism prosecution after 9/11.
As a whistleblower, when I blew the whistle back in 2001 in the case of the American Taliban John Walker Lind, our government called me a traitor a turncoat and a terrorist sympathizer. Now, 10 years later, I am representing other whistleblowers. But it's gotten even worse because Obama has started an unprecedented war on whistleblowers by prosecuting them under an antiquated World War I law called the Espionage Act, which makes them enemies of the state.
Although the administration says that it did sign a statement addressing concerns for the constitutionality of the NDAA, assuring people that U.S. citizens would get a trial, the signing statement does not specify whether it is a military trial or a civilian trial.
What are we supporting? We're supporting justice, we're supporting freedom of the people, and we're supporting the right to a trial and the right to representation in court if we are detained, which we are very often here in New York and all over the country if we protest against the government.
I think it's a travesty that this administration, who campaigned on hope and change and ignited the progressive movement in this country, has gone on to pass laws and regulations and executive orders that, if a Republican administration had enacted them, that millions of people would be in the street protesting. It's a Trojan horse administration, and it's put the progressive movement in this country to sleep.
Now, the plaintiffs say the reason they launched a campaign alongside the lawsuit was because the lawsuit was facing enormous challenges, notably a compromised legal and judicial system, a mainstream media that's not focusing on the topic, and a general public that for the most part has been blind to the provisions of the NDAA, notably Section 1021 that is up for debate. Campaign supporters say that they're optimistic. They already sent 60,000 emails to Congress waiting for a reply. That's all the time we have for this edition of Inside Out. Thanks so much for staying with us and watching. Remember, you can always send me your emails to insideout@susanmadaris.com. I'm always looking forward to them. You can also follow me on Twitter for latest updates and discussions. Until next week in another show, goodbye.